Ladies and gentlemen, gentlemen and ladies and gents. There is a slight delay at the beginning of the video, so that's why I had to repeat it. So I apologize to that for that being the case. I was doing some research. I told you guys about this Jehovah's Witness whose name was Hayden Covington. I only knew a little bit about the person, and I call him the person because he was, pay attention, don't take it the wrong way, just another Jehovah's Witness. Now, not that any Jehovah's Witness is just another Jehovah's Witness. In other words, we don't put people on pedestals. Although you'll hear people talk about Jehovah's Witnesses and they'll put some of them on a pedestal as if we revere these men, but that's not the way it works. Well, Hayden Covington, you can look up his name on Wikipedia, and it says Hayden Covington, born January 19, 2011, died November 21st, 1978. Now, he was a legal counsel for the Watchtower Bible and Tract Society in the mid-20th century, and he argued numerous cases, a total of 37 victories before the Supreme Court. Now, ladies and gentlemen, he put 44 cases before the Supreme Court. He won 88% of them. I just found this out today, and I promise you, look at that. He was admitted to the Texas bar in 1933. Now, that's interesting. I promise you that I would not have been more interested in him had I not learned that he won 88% of his cases. Prior to 2013, I had won 86% of my cases. I'm now down to a measly 84%, 83, 84 if you round it up, okay? It's just the way things are. Now, something else, Joseph Rutherford, they used to call him Judge Rutherford because he was an attorney, not a judge, but he was an attorney, and thus they gave him the nickname Judge Rutherford. He was that good of an attorney. Now, understand this. Don't read this stuff and think you're going to get everything, because none of this junk right here attached to the group's teachings. Sorry, you don't call 8 million people a group. All right? You call 15, 20 people a group, but that's what they want to do, and let them do it. We don't care. However, there's going to be some issues going on here, and I'm going to try to explain some of it, because if some of you go to reading about Covington, and yes, this video is only about him, okay? Not a tribute, so to speak, because I'm only highlighting his victories, okay? That's what I'm highlighting. Now, there was this issue that many people had. He became vice president of the Watchtower Bible and Tract Society. The Watchtower Bible and Tract Society, in order for them to distribute literature, they had to be incorporated. Thus, they incorporated themselves in 1879. How do you remember that? How do you know that? Because it's a basic history thing. Okay, when they incorporated themselves, they became known as the Watchtower Bible and Tract Society of Pennsylvania. Now, originally they were the International Bible Students. Apologize, said Watchtower Bible and Tract Society. They became Watchtower Bible and Tract Society later. They were known as the International Bible Students. Originally they were called the Bible Students. Why? Because they studied the Bible? That's right, the name fit. So, International Bible Students. And they did it internationally, i.e. International Bible Students. And they're still incorporated in Pennsylvania to this day, but headquartered out of New York. There you go. That's that story. However, the individuals that Jehovah's Witnesses refer to as the governing body, well, those are the individuals who keep the organization organized. That's right, governing organization, governing body. So they keep the organization organized. They are the ones to make sure that this congregation over here isn't allowing fornication, adultery, slander, gossiping, backbiting, bringing reproach on God and his name. And that the other congregation over here isn't doing the same, and the other congregation over there ain't doing the same, and the congregation over there in Istanbul isn't doing the same, and the congregation over in Italy isn't doing the same. They're the ones who keep the entire organization organized. They're also the ones who keep us on the same page. Think about it. If you're serving the same God, you should be on the same page. You should be doing the same thing. Should not be like some groups where this group over here is doing one thing, and this group over here is doing the same thing, but then they're doing something different. This group over here is doing something completely different than the other two. and they're teaching different things, but they all claim to be a part of the same organization. Can't have that. So it has to be organized, i.e. a governing body. The same as they had when Jesus, right after his death, they had what was called a governing body, or the elders of the congregation back then. If you don't believe me, go back and read Acts the 15th chapter. Wait a minute. Hold up. Y'all know me. Y'all know how it is. I was looking up something else, well, for later, because I'm going to be looking up something else later, and I'm going to need this because I'm writing a motion for somebody, and I'm having to put the appropriate information in there. But as I told you, Acts the 15th chapter, let's find out what was going on in Acts the 15th chapter. Not Acts. We ain't chopping no heads off, okay? Acts, the 15th chapter. 8. I just had to ask you something. Acts, like Acts of the Apostles, not Acts like Hatchet of the Apostles. Ladies and gentlemen, what happened is that the apostles and the officers of the church, or the elders, how do we know that that's what it would have said, should have said, if they had allowed it to say it? Well, let's go all the way back. Got to go back. A lot of versions of the Bible here, y'all. A lot of versions. Okay? A lot of them. Let's go Montgomery. Montgomery, the apostles and the elders. Okay? That's how we know. It's just the translation issue. Some versions will say, as you saw, officers. Other versions, like the King James, will say elders. So there was a group of men who helped keep things together. And here we are. And when there had been much disputing, Peter rose and said, "Unto them men and brethren." Okay, so this is one of the scriptures who speak about those men who kept the congregation organized. Remember, Paul and Barnabas had come back with information because there were certain discussions going on. Should go up to Jerusalem unto the apostles and the elders about this question. Why? Because they didn't want there to be disunity. So Jehovah's Witnesses follow the same pattern of unity. Okay, that's what I was trying to say. And why didn't you just say it? Because I have to show it to y'all. I can't just open my mouths. That's right, I said mouths as in many. I gotta close that. Opera, this side of Windows always gives me the problems. I just don't snooze. And this one don't normally give me a problem, but it gotta go. Bye-bye. All right, now let's get back to Hayden. The governing body is usually individuals who are said to be of the chosen race, the anointed, those who profess to have a different hope. We're not going to go into a conversation about that. That will take too long. And even if I explained it, people just wouldn't get it. This is not something they imagine, not something they dream up or whatever. Hayden didn't have that hope. He had a different hope. Well, everybody of the governing body and all the officers of the corporation are said to be of those who have that particular profession. Hayden did not. So he resigned as vice president because, in essence, there wasn't really a choice. He had to comply with the wishes of the organization, and so he did. However, he later, because of some other complications, was disfellowshipped from the congregation. He was then reinstated sometime thereafter. That's to get that out of the way. And you don't hear him. This is 2 days before he died. What we're reading right now is 2 days before his death. This is how ironic this is. Okay, but we're going to let him. I honestly wish I could play the audio for you. They say that they had the audio, but they don't have the audio. You click on this, the original interview. See, listen, hold up, listen, wait a minute. Oh God, oh no, can't listen there. It's been removed. Okay, it's been removed, you guys. And this is a place called Host Monster. Whew, they're a monster, all right. Anyway, an interview with Watchtower. See, they want to put the name Watchtower before the name, instead of just calling him Hayden Covington, because he didn't just represent the Watchtower Bible and Tract Society. Do you know who else he represented? Let's talk about it. Uh-oh, I can't. Oh, there we go. Whoo, doggy. I thought I was about to say I can't switch. Back to the other one. He represented this guy right here, Muhammad Ali, in the draft dodging case. Okay, that was the attorney representing Muhammad Ali. And at this point, Muhammad Ali is a Muslim when he represents him. So that's why when they put Watchtower before it, he didn't just represent the Watchtower, he was the lead attorney for the Watchtower Bible and Tract Society. But we're going to have him tell it, okay? Just want to do this, and whether people pay attention to this or not, it doesn't matter. This is history, ladies and gentlemen. You don't win that many cases before the Supreme Court and there not be something about you, okay? He has 2 records that will never be repeated. First, he's won more cases before the Supreme Court than any other attorney, beating out, and yes, I can say beating out by a long shot, Thurgood Marshall, by more than 10 victories ahead of Thurgood Marshall. No other attorney will have that opportunity, ladies and gentlemen. No other attorney on this planet will have that opportunity because the Supreme Court only meets in 2 sessions and they don't take every case. Okay? So it will never happen again. So his record will stand until the end of time before the United States Supreme Court. Nobody else, go ahead and take a look. Nobody else is even anywhere near close. Okay? So it ain't going to happen. So his record is going to stand, and there's nobody on this planet who can outdo that. That's his record. Not as a Jehovah's Witness, but as an attorney. It shows you how good he was. Now, that's the first thing. The second thing that everybody needs to pay attention to is when he represented Jehovah's Witnesses as their lead counsel for the Watchtower Bible and Tract Society, he had more victories. I believe the total was 11, but I could be mistaken. It's either 9 or 11. They have the most victories for one individual group, and all of their victories led to your freedoms. It is because of these cases, and when you get a chance, go ahead and take a look at these cases right here. These are not all of the cases he's won, but cases he argued before the Supreme Court. Remember, there are 44 different cases he brought before the Supreme Court. 37 of them he won. So this is not all of the cases. These are just the prominent ones. But I will definitely tell you Cantwell versus Connecticut. That's the one we talked about. Okay, now remember, he became an attorney in 1933. And within 7 years, he's before the Supreme Court. He also talks about the meeting he had with Harry Truman. I was about to call him Harriet Truman, okay? But yeah, letting you guys know about the Muhammad Ali case. Now, again, I would not, well, let's do that. I wanted to see how many cases he won before the Supreme Court. And so let's see how many cases were actually brought before the Supreme Court. If it's going to tell me that. Witnesses brought 23 separate First Amendment cases before the Supreme Court between 1938 and 1946. 23 cases, okay? They didn't win all 23. Many of them were not victories. However, many of the cases were brought back up again before the Supreme Court. That's where certain decisions were made, especially the Board of Education versus Burnett, okay? That's where the issue is. Now, I'm looking for the victories, so let's see. I don't see the amount of victories, and that's why we went here. Let's see which number is that. That's 28. So we're going to have to go roughly about 28 and see. Nope, don't have a number there. Thought I would get a number, but we don't get a number, y'all. And this is all the cases they have throughout the world, but we were talking about the United States Supreme Court, and I don't find how many cases they won before the Supreme Court. I see them going before the Supreme Court in Canada and France and Germany and Russia and the European Court. You see, it's not just the United States. This is all over the world. They give Jehovah's Witnesses issues. So Jehovah's Witnesses have to do what they legally can do, and that is use the system, i.e., the same policy I use. I use the system in order to get some correction. Okay? So I don't see the number of victories. I thought this would take me to it, but it didn't. Sorry. 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 So we're going to go back here. And again, this is about Hayden Covington. So I do know of those 37 victories, he won at least 9. I believe it is 11, but I know he won at least 9 before the Supreme Court. Yeah, and I don't feel like looking it up now, but now I want you all to note that the person who transcribed this, they are going to add stuff and take stuff and put stuff in when they're not supposed to be adding stuff and putting stuff in. Instead of just giving you a transcript of the interview, they think that you're too dumb to know what was said. So I will let you know of what junk they're adding. But anyway, no, this summary is typed from a taped interview with Covington completed November 19, 1978, 2 days before his death. The interviewer is Jerry Murray and his wife. To make sense of the transcript had to be edited for clarity and fluency. Excuse me, you mean he wasn't a fluent speaker? The man spoke before the Supreme Court. Anyway, the original interview is not here, and the original WAV files are not there. They've been taken down. Not everything on this site is negative towards Jehovah's Witnesses. Now, pay attention. Not everything on this site is negative towards Jehovah's Witnesses, but they let you know that they are biased at the very beginning. I didn't read that until just now. That's my first time seeing it. That's why I could tell you ahead of time. I read down to here, and when I read down to here, I decided I'll do a video and let you guys judge for yourself. In fact, they are fine people with a heart for better things in life than, for the most part. This file is an example of some of the hard and fearless workers that once graced the halls of Bethel, in spite of how they were treated thereafter. Apparently, these individuals thought Covington was treated rather harshly by Jehovah's Witnesses. However, here's the point. Covington doesn't say this. He didn't feel that way in the end. I haven't even read the whole thing, but I know for a fact that when he was reinstated, he was reinstated. Okay? And that's not because Jehovah's Witnesses like you. That means that whatever he was doing that brought his life out of line with Scripture, he brought it back into line. Coming from a person who has been in the past disfellowshipped as one of Jehovah's Witnesses and reinstated as one of Jehovah's Witnesses, let me say for a fact, it was my past actions that caused that to happen, not Jehovah's Witnesses. I don't have any anger towards Jehovah's Witnesses. Jehovah's Witnesses didn't cause me to sin against my God and against my fellow man. They didn't do that to me, so why would I be angry at them? The disfellowshipping was absolutely necessary. The congregation must be kept clean, and Covington understood the same thing. Other than that, he would not have gone back to be reinstated. Reinstatement is not no snap of the finger. That is work. Trust me, it's work. All right, took me 3 years. So when I say it's work, it's work. But enough about that. Covington was born January 19th, 1911 in East Texas. And this is him talking. I was raised on a farm in a place east of Dallas. I worked my way through school after that. My father was supposed to be in the Texas Ranger Force, and he was transferred to San Antonio, Texas. And that's where I went to law school. And he says, Brother Murray, so this is a Jehovah's Witness that's interviewing him. And he's probably interviewing him for the Watchtower magazine. So honestly, I believe this article could have been taken from the magazine, but I'm not certain. Okay? Murray says, how did you happen to come into the truth? Jehovah's Witnesses refer to it as the truth because Jesus says you'll know the truth and the truth will set you free. Ever since the Truth book that I've mentioned a couple of times, the largest selling book on the planet, with the exception of the Bible. At the time that this was written, the Truth book had sold Several, uh, probably about 10, maybe 15 million at the time. And that was sold because they would give it to the public for the printing costs. So we had to pay for those books at that time. So it is the one of the most widely distributed publications in the world's history. It's called the Truth Book. So when he asks him, how did you come into the truth? It is where Jesus gives the phrase, you'll know the truth and the truth will set you free. So it's a internal phrase used by Jehovah's Witnesses. Covington says, I came into the knowledge of the truth because my father was transferred from San Antonio, Texas, down to the valley as a Texas Ranger, or down to the valley as a Texas Ranger. After that transfer, I had to have some place to stay. So I stayed with two friends of mine that went to the same school. They asked me to move in with them, and the father, who was the head of the family, was in bad health, and he had all of us come on Sunday to listen to him talk about world conditions. He interested me, and I got very interested in what he had to say because I myself was fed up with the way things were going, and like all young kids, I was dissatisfied with the establishment. And I was very much so at the time, and I was flirting with controversial ideas, and he was full of controversy against the system of things. What he preached appealed to me very much, and so I listened to him. And he would turn on the radio, the KTSA, that had recorded broadcasts of J.F. Rutherford, as he was called, and it was Judge J.F. Rutherford, as he was called and known. So he listened to our listening, and I was very pleased with what I heard. Now he goes on, he says, note, Covington did not become a Jehovah's Witness due to his love for the scriptures or God, but for his youthful rebellion. That's not what Covington said. Covington said that that's how he first got knowledge of it. Doesn't talk about his love for anything. He never mentioned anything about where he got love for. He's just talking about how it began. Brother Murray says, what's the fact that Brother Rutherford was a lawyer? Did that impress you? Did that make it more interesting? Covington said, well, he presented things in a way that was incontrovertible. Okay. Ladies and gentlemen, as I try to tell people, I try to present facts to people. It's when I got to the incontrovertible point here that I decided to do this video, because I wanted to let you know that I am not so unique. I am not the first of my kind. I too like Rutherford. Okay, I too like the strong, how would you say, stature of Rutherford. But not because he was a Jehovah's Witness, but because of how he delivered things, because of how he spoke. When that man got up and said religion is a snare and a racket, and he knew the backlash that was going to come after him because he called religion a snare and a racket during a time of religious fever in this country, I had a lot of respect for Rutherford. But anyway, let us go on. Incontrovertible to me. As a lawyer, I could see that he knew what he was talking about 100%. He was very persuasive, and I was a ready and willing listener. And I was willing to join up with him in his opposition for the truth. Pay attention. This is why he said he was willing to join up, not because of his youthful rebellion. Ambulance passing by, I apologize. I was willing to join up with him in his opposition for the truth, for the scriptures, people. But according to these morons who put up this site, it wasn't because of his love of scripture, but because of his youthful rebellion. And he says that it was his opposition for his love of truth. That's because they did not know what he meant by truth. Okay? Again, if you're one of Jehovah's Witnesses, you clearly understand. Brother Murray says, you were right for the truth. Pay attention. Again, they're using the same word. So this word is their catchword. I want you to pay attention. It's a catchphrase. It's a word used by Jehovah's Witnesses. When did you first meet Brother Rutherford? Now, here's the thing, ladies and gentlemen. Brother Rutherford was the president of the Watchtower Bible Society at that time. So basically, for you to go and meet him wasn't a big deal. You could walk up to him and shake his hand, no problem. Okay. But remember, he was in New York. So let's talk about this. In Houston in 1900, and I forgot the year, way before I came to Bethel, I went over to Houston with a group of brothers that knew they were having a special meeting over there. And Brother Rutherford was there because Brother Isaac lived down in Houston at that time. He's dead now, Joe Isaac. He was a great friend to Judge Rutherford, and I heard his name all over Texas. Murray says, tell me this. When you took the truth, did you begin to go to the meetings? And how did your daddy react to that? Your daddy, I like that. That lets you know how old they are. Well, he got very hostile against what I was going, when I was going to the witness meetings, because he had great ambitions for me to be a politician. And I was then working in the county courthouse, in the county clerk's office, and I had a political job. Whenever they were out campaigning, I was out preaching. So I had a political job and a political office, but I didn't go along with it. Murray says, when were you actually admitted to the bar? I was admitted to the bar in the year of 1933. Murray says, so you practiced law for a little while before you went to Bethel. Covington says, oh yes, I was a very active practitioner of the bar for the state of San Antonio, Texas. After I took the bar examination, and incidentally, I took the bar examination a year before I graduated and passed it. Look at that. He took the bar examination a year before he graduated from college and passed the bar. Okay, before he even graduated. Then you still had to go an extra year. Covington says, yeah, I had to go an extra year to get my certificate of graduation. Murray says, did you set up your own law firm or did you join a law firm there? Covington says, I worked for a big law firm when I was admitted to the bar, and I passed it with such high grades that the head of the law firm, Mufferson and Berkson, came and offered me a job. Sister Murray says, how did you get involved then defending the witnesses and working brothers? Covington says, that came about after I quit the Morrison firm and went over to R.H. Mercer, who did a defending of damage suit for the county casualty company in San Antonio. And there were some brothers who got arrested down in the valley because of a meeting that was held down there, and I was down and appeared on their behalf and got the case thrown out. And then it was my name reached the society, and they assigned me to represent the society in a will contest case up in Carville, Texas. I handled that for the society, and then the brothers got involved in a controversy with San Antonio police, and that is when I got into the matter with Brother Heth. We were having information marches, and the cops were trying to stop us, and it became necessary for me to have a conference with the mayor of the city of San Antonio on whether Jehovah's Witnesses have the right to engage in information marches, carrying their signs to that religion is a snare and a racket. See what I tell you, Rutherford, religion is a snare and a racket. Look, ladies and gentlemen, you do not go about in the 1930s talking about religion as a snare and a racket when the government has made sure everybody had no other choice but to fall back on religion, since they had just collapsed the economy, made the people as poor as dirt. When people are at their worst, when they're at their bare minimum, who do they turn to? They do not turn to religion. And now here you got somebody telling people religion is a snare and a racket? They weren't standing for that. All right, let's get back to Murray. But how did you win the case? Covington says by pleading with the mayor, he saw that we had the right I made him. Well, I didn't make him. The Lord made him. But I was the one that offered the proposition. Let's see, Brother Heth was in San Antonio on occasion for that visit. Brother Heth was the secretary for Brother Rutherford at the time, the secretary of the society. Well, I believe he was just the secretary, not the actual secretary for the society, but the secretary for Rutherford, his desk office secretary. Well, anyway, Sister Murray says, so when he saw you there, he invited you to Bethel? Well, he invited me not to Bethel. He invited me to attend Madison Square Garden Convention of Jehovah's Witnesses. Brother Murray says, is that the one where they did all of the riots? Covington says, that's where the Catholic Action tried to break the meeting up in 1939. On the record, Government and Peace, and you can hear the mob action from up the stairs. When the mob started, Brother Heth got down off the speaker's platform because he was in charge of all the ushers, and he headed up there, and when he headed, I headed there too. He went up to the Mandarin stairway up into the old Madison Square Garden, not to the one that's there today. I followed him and we went together. They were screaming and mad. This was the same sort of noise that you would hear on the Government and Peace record, was yelled into our ears as we were going up to maintain law and order in the religious gathering. Okay, ladies and gentlemen, Covington now says that the cops were on the outside and acting hands off, allowing those, I cannot begin to tell you, I don't know the word, Coglanites or Coglanites, to go ahead and to break up the meeting or to try to break it up. We went up and we had canes to maintain order, and we tried to push the mobsters out of the way. And when we did, one mobster grabbed Brother Heth and hurt him very badly physically. And that's also written up in the society's publication. They grabbed him by the private parts as he was going up the stairways, and he hit the mobster over the head. Sorry, Jehovah's Witnesses are permitted to defend themselves. He hit the mobster over the head with the cane in order to break up the crowd that was coming up around us. And when he did this, the cops moved in from the outside. Now, we don't want to talk about this. We don't want to talk about they were in conspiracy working with the mob, because that's this individual adding that. And they put Brother Heth under arrest because of his having hit one of the mobsters with the cane. He was in the right, Brother Heth was, but the cops didn't think so, and they went ahead and did their part, helping the mobsters, and took Brother Heth into custody. Ladies and gentlemen, he hit the guy with a cane. The guy grabbed him in an area that was unpleasant, and he hit him with a cane. The police can use him as being not the aggressor, but it was the fact that he didn't return like force, is what they would say, if it was today. I know it for a fact. Well, anyway, then I became the chief witness for the defense, meaning that Brother Heth. And when the case went to court, I was called up from San Antonio, Texas to testify. I made 2 to 3 trips up on the train. They were 2 and 3 day trips. Anyhow, in the end, Brother Heth was tried by 3 judges. They were black-robed representatives of the state of New York to enforce the felony law, and they were going to try and get him. But the judges ruled based on the testimony that I had gave supporting Brother Heth's self-defense, that he was not guilty. They held that testimony was given by a member of the bar whom they believe was more credible than the mobsters that had testified against him. So Brother Heth was acquitted, as a result of Jehovah's provision for having me there to give testimony on his behalf. Now, first of all, you'll hear him say things like this, okay? These people want you to believe that he was against Jehovah's Witnesses, against everything, and that's not the case. And when he speaks about things like the society, he's speaking about the Watchtower Bible and Tract Society. When he makes those conversations, those comments. When he speaks about government and peace, that was a recording, government and peace, that was present at the time. You probably, if you find one, you'll be doing good if you will find that particular recording. Went too far. All right, down Sister Murray says, I remember Brother Rutherford on the record saying that they will not break up this meeting, and he just went on nonstop. And Covington says, he says, by God's grace, the Nazis and the fascists will not break up this meeting. And that's the way it was, not broken up, because the brothers maintained law and order. Brother Murray says, it was not broken up because you used those canes. At the time there was already some litigation going on. For example, I think the Lowell case. Covington says the Lowell case had gone on up to, and the judge had authorized the appeal of that, and Mr. Mayall, and I'm going to make this a little bit larger because it's small for me and I know it's small for y'all, and we just going to get the Mayall thing going on. So give me 1 second so we can get that Mayall. Nope, that's double barrel. Didn't get to that part. There it is. Okay, Mr. Moyle, who was at the time at Bethel, handled that case. I had nothing to do with that case. I didn't come into the Society's Supreme Court cases until after the Snyder case was argued. Brother Rutherford argued the Snyder case. You'll find that Rutherford won several cases before the Supreme Court as well. Snyder against Irving, New Jersey. Oh, Irvington, New Jersey. Okay, Brother Rutherford and I were in that case together. This case was in an ordinance against literature distribution case. Now the flag case was a different case, and that came up for hearing in 1940. That was adverse to us, in other words, against us, the first one. And then later, they reversed themselves as a result of our taking that up. Understand something. At this time, and I got to do the math because it is necessary. So let's see, 1911197876. Oh, he's not even that old, ladies and gentlemen. He's not that old at all. He was only 67 years young when he passed. That's interesting. But he is able to run down the dates of his case and tell you what year everything happened without missing a beat. Okay, so that was the point where we went to the Madison Square Garden case. That's the one where the mobsters tried to break up the meeting in 1939. So it must have been shortly after that that you were invited to Bethel. Covington says, on account of the fact that I had made a firm defense for Brother Heth and the lawyer for the society pulled out, he didn't believe in the self-defense and he quit. Brother Rutherford, and ladies and gentlemen, the brother hit the guy with the cane, and again, if that were to happen today, there would be some questioning as to whether or not that would have been appropriate. Okay, and that's why the other brother pulled out, because we are a non-violent group. However, we are permitted to defend ourselves. Okay, and the guy grabbed him, but we believe in self-control. That it doesn't matter what you believe. The one who pulled out, that was his conscience, his belief, and he had every right to do that. Nobody got mad at him. However, Brother Rutherford was in need of somebody, so he called on me, and I was not aware what was going on at the time. But when it did happen, he invited me to come, and I came. Murray says, so you one field of law, were in one field of law, but you almost got into constitutional law. Covington said, yes, I was originally in casualty insurance, defense, and personal injury, and representing insurance companies for damage suit cases. Just like you see, pay attention to the, what's the name of that case? The attorney, dang it, Thurgood Marshall. Look at the movie. You'll see that the attorney who came in and helped Thurgood Marshall was an attorney who helped in personal injury insurance and personal, representing insurance companies. Interesting, ain't it? Then, when I went to Bethel, I was in a very different area altogether, but still, I had had enough trial experience and appellate arguments and court experience that it was easy for me to shift into the position of defending Jehovah's Witnesses, and it was good because I was able to do what I liked, which was defend my client. Also, having got a righteous cause gives you a double barrel. Okay, Sister Murray says, that's right, a cause that you really believe in. Covington, I went to Bethel in 1939. Brother Rutherford called me in, but that was after the Madison Square Garden riot case, and that was because of the fact that the other lawyer by the name of Moyle quit and left Rutherford holding the bag. Rutherford, he didn't, and I'm going to get you, Covington, he didn't leave Rutherford holding the bag because Rutherford was a very capable attorney himself. I got an invitation to come by special delivery from Rutherford, and I went immediately. I had to transfer cases to a dozen or two lawyers in order to make that change. Thank you, Covington. Anyway, Murray says, you and Brother Rutherford were on a couple of cases together you mentioned. I always think of you as a lawyer and him as the writer, but was he a pretty good lawyer? Covington says, oh yes, he was. He was very, very good. He was an eloquent speaker and maintained dignity, and he got very high respect from members of the court that listened to him argue the Covington case. Covington, YouTube this case right here. Okay, this young lady, I believe she's still alive. This was a case where the school beat her and her brother for not saluting the flag. Ladies and gentlemen, when you get a chance, do yourself a favor on the flag salute case, the Covington case. You can find the interview on YouTube with Phil Donahue. Phil Donahue did the interview with her. Okay. Well, anyway, ladies and gentlemen, this Covington case changed everything. They lost this case, but the case went back in the court, and it was subsequently the defeat that they had was overturned, so it actually turned into a victory. Anyway, go ahead and do your research on the salute of the flag. You will be surprised to learn that the original salute of the flag was in the form of a Heil Hitler, just with the palm turned upward. I promise you, if you really do your research and you find out that people originally saluted with their hand held up and facing upward, as opposed to Heil Hitler, it was the same salute, people. But now they have you place your hand over your heart because they don't want it to be as offensive. Got to know your foundations. Murray says, so you got started in 1940. What were some of the first major cases that you were involved in? I know a little bit about some of the cases, but what were some of the first cases? The flag salute case came along in 1940. Covington said, well, the first flag salute case I worked on with Brother Rutherford, but I had nothing to do in the argument of that case. Brother Rutherford argued that one, but he did a good job. No, he didn't, because he's going to say he lost that case, but he did a good job anyway. And yes, he did do a good job. It's just one of the judges on the Supreme Court was not having it. That judge was later replaced. And next thing you know, when they went back to the Supreme Court ruled in their favor. Anyway, the reason that it was lost was not because of Brother Rutherford. Look, he's agreeing with me. But because of the times we were in. The war was going on and the heat was on us from every angle. Then for a while, the cases just piled up. That's Here is where you're going to find out why the Supreme Court all of a sudden, because of these cases piling up, decided that, oh no, whenever we make a decision in one case, it's going to be recognized in every court, okay, in every state. Before that, the Supreme Court made a decision in the state of New York. That case only applied to New York. You understand? Ladies and gentlemen, prior to 1940, I believe it was 1942, prior to 1942 or 41, if you're using Supreme Court cases prior to 1942 or 41, you want to use cases that was in the state where you reside or in the district where you reside, because it only applies to that area. I know. Even you attorneys, those of you who've been studying law, thought you knew better. But it was only because of those cases piling up that the Supreme Court made that decision. So it was based on Covington's going before the Supreme Court and handling those cases, that they didn't want to keep making the same decision in every single case, because they would have to overrule themselves, and they would be, that's just what I like to do to the courts. I like to use their own words against them. And that's what they were doing, using their words against them, to where they finally just said, no, if we make a decision in one case, it applies to every case. So they would not be put in that position. Covington says, oh my, yes. They were coming at us so fast and furious. It was an 18-hour day for me to cope with it. But I was young and dedicated and devouring of any opportunity that I had. I kept on going all the time. I was happy to do it. Ladies and gentlemen, it took its toll. Look, I understand when he talks about 18-hour days and worrying about and trying to take care of and trying to help. Murray says, some of these things here that I am not too familiar with, you can tell me about some of them. For example, I know about the Harlan, Kentucky case, but what can you tell me about this Cornersville, Indiana case? Covington says, well, that was a mob situation that occurred while we were trying that seditious conspiracy case in Cornersville, a hotbed of American Legion action, and they ruled the whole town. In the Cornersville case, I used Brother Franz, another member of the governing body, later member of the governing body, as my witness, and then the jury was put on, and it was necessary for me to get to, I guess you're saying, to get out of the case. And I finished the argument in the case in Cornersville, and I tried to get a postponement of the case in Maine, but they wouldn't put it off. As a result, I had to race from Indianapolis to Cincinnati to catch a plane to Boston and to save my life, because that night they had conspired to kill me. I went to catch the airplane from Cincinnati to out of Cornersville, and then Brother Victor Smith, who was with me as a co-counsel, he is now dead. He stayed, and he and his wife, Sister Smith, were mobbed by the crowd, and as they were mobbed them that night, in the darkness, after the case was over, they were screaming and yelling that they were going to kill me that night. The Lord delivered me at the right time, and I would have been killed that night. I wanted to stay there for the verdict. The verdict was adverse, and I took an appeal. I had to go back to take the appeal afterwards, and the same group of conspirators were there, and I got in and out in a hurry. We made the appeal effective and got the case reversed on appeal, but that was after the tremendous effort we put forth, and a lot of blood, sweat, and tears were involved. It was part of the conspiracy to wipe us out of Cornersville, but by Jehovah's undeserved kindness, they didn't. The good testimony was given, but some sisters were convicted for conspiracy and were given jail terms. I got them out of jail on bail, and we appealed the cases to the Supreme Court of Indiana. It was reversed, and they were acquitted by the Court of Appeals. The decision came down on Pearl Harbor Day. Interesting. Oh, yeah, again, that's addition. Anyway, Brother Murray, I noticed that you got a note here about Oscar Pillars, a brother that was in Texas. He says, yes, he was a brother that was down in East Texas to show the intense prejudice in that area. They literally mobbed him and hung him up on a telephone pole, and the rope was cut by steel bars on the telephone pole, the angle bars. That was the thing that saved his life. Yes, hanging of Jehovah's Witnesses, people. This wonderful country, the land of the free, home of the brave, and all that other stuff. Murray says that later went to court, and the persons that were guilty of tying him, trying to hang him and kill him, fled the state. Now, of course, this Harlan County, Kentucky, Sister Murray and I served over there near Harlan County, and we heard of some interesting stories about Harlan, Kentucky. I've not heard any stories about Harlan, Kentucky, but I'm sure that Harlan, Kentucky is a wonderful place. I am sure Harlan, Kentucky has no racism and no other type of history of showing prejudice towards any group or any bodies. Covington says, and Somerset, Kentucky too? Somerset and Harlan were both involved. Really? Somerset sounds, look, ladies and gentlemen, Somerset sounds like a tranquil place. Interesting. Murray says, now, what was their objection to the witnesses in Harlan? Well, the same as here. That was where the prosecutor said, that was where the prosecutor said that if they got me back down into Harlan, he was going to boil me in oil. Really? They had a conspiracy charge against the brothers, sedition, conspiracy charge. I then filed an injunction against the prosecutor of that case in federal court, in London federal court, and I got an injunction against the state of Kentucky, and it's standing yet to this day, knocking that sedition law out as unconstitutional, and the federal judges that heard the case gave us vindication. Ladies and gentlemen, this right here lets you know, and if I had not read this, you would not know this, that you can get an injunction against a prosecutor in cases that you have. You just have to bring up the right argument. They challenged the law as unconstitutional. That's how he was able to get an injunction against them, but he added other things into that. I don't have a copy of those pleadings, but you all can do the research and get a copy and see what he brought up. Okay, it was highly controversial and hotly contested case. The thing that was interesting was that the prosecutor said that he was basing his charge on the grounds that the literature was conspiratory and seditious. This is what Russia is saying about the publications of the Watchtower Bible and Tract Society. I invite you to go read any of their publications and see if they talk about sedition and or conspiracy. Just go right ahead and tell me if you find anything, because that's what they're saying. Then the chief federal judge said, the district attorney, it's now 11 o'clock and the court will adjourn and we'll be back tomorrow with proof. Oh, and you will be back tomorrow with proof. Same thing they did in the court in Russia. So the court adjourned, and when we came back the next day, of course, he had no proof. All he had was all of those books, and then when he was making that statement on the other guys in the room, to the other guys in the room, that if he gets Covington back down to Harlan, is going to boil him in oil. Really interesting. Murray said, I understood that some of the brothers roomed next to his room that night. Covington says, yes, they were, because we had taken up all the hotels and all the officers of the law had to bunk up. Brother Murray says, is that where they spent the whole night researching the literature? Yes, that is where the sheriff and the marshal said the old Daniel Boone Smith, to turn out the lights, we need to get some sleep. Oh, that was funny. Okay. Yes, that's real funny now to tell about it, but it was pretty tough at that time. Ladies and gentlemen, what was happening is that they had to double book the rooms to where the sheriff and its officers and the witnesses had to all be in the same room. The attorneys for the witnesses had to all be in the same room. So they're up all night doing research, and the sheriffs can't get any sleep because they're up all night doing research and the lights are on. And you know you can't go to sleep with the lights on. That's a waste of electricity. Anyway, Covington said, yes, our life was at stake. When you are batting with your back to the wall, but Jehovah gave us vindication. But it was a rough time. The Murray says, you're not kidding. You know, there are a couple of cases that you didn't have down here, but I know about them personally. For example, did you fight the case with Jones versus O'Blancone? I don't know about Jones versus O'Blancone. Might be interesting. Covington said, yes, that was the case that was taken up to the Supreme Court involving the validity of a license tax law. A license tax law. And that came up from Alabama. We lost at first, and that was a companion case to the Jones against Opelika and Jobin against Arizona, and another person against the state of Arkansas. Those three cases were put together, and the Supreme Court heard them, and they decided them adversely to us at first. Then on rehearing, they set aside their opinion, but that didn't come automatically. We had to argue with our backs to the wall, and that's when Justice Murphy filed his dissenting opinion to the case. He complained about Jehovah's Witnesses being prosecuted by mob violence and all other sorts of conspiracies that public officials had used to stop their work. And that's when Murray gave his dissenting opinion in favor of Jehovah's Witnesses. And then after that, the other cases were taken in from Pennsylvania, and that meant that the cases would have to be reopened because there was a very serious question that the court hadn't grabbed hold of. And it was good that they brought the other cases in, because otherwise the cases would have to stand and wouldn't be reheard. Ladies and gentlemen, this is how the other victories were acquired. Because they kept going back into the court and into the court. Even though they would lose a case, they kept going back into the court asking for a rehearing. And they brought in the right motions. In a day or so, I'll be doing another video showing you guys how to get your rehearing on your cases where your houses have been taken. But you're just going to have to bear with me. Those of you who are listening, just pay attention, because I'm going to take you on this little trip. I'm probably not going to read the whole interview because it's a lot, and we've already been going for a minute. Okay? Now, hold on. Got to get back up to where we were. We haven't talked about the notorious Catholic. We're right here. As I understand, the license tax case in municipality would say to sell your literature in our town, you've got to have a license. Yes, if you wanted to come and sell literature here, you got to have a license. But when you went to get the license, they wouldn't sell you one because you didn't qualify. You didn't qualify. And that's the way we got persecuted, on account of not having a license. But because we believed that the license was ungodly anyhow, we never would have got a license anyway. And we were defending the case because we were making an imposition upon our constitutional right and contrary to our conscience. Judge Murphy filed a dissent in that case. Murphy got a good name among us because he was always dissenting in cases in our favor. They wrote an article about him in a law review. Some guys did. And the effect of it was Justice Murphy was ever sainted. It will be by one of Jehovah's Witnesses and not the Catholic Church, as he was a notorious Catholic. See, Murphy was actually speaking in defense of Jehovah's Witnesses, but he wasn't so much speaking in defense of Jehovah's Witnesses as he was speaking in defense of constitutional rights, which was something nobody expected this particular Murphy, as opposed to Murphy to do. Anyway, let's continue, shall we? It is odd that he would be so strong for justice when he hadn't had that background. He was very in favor of what we were doing, and he knew that the life of the country depended on its success. In other words, see, if they take away the rights of your being able to assemble peacefully, your right to being able to speak freely, your right to being able to go and, let's just say, share your beliefs with each other, then the whole country falls. And that's what he's saying. He says, but not all of the justices were that way. For example, Judge Frankfurter, oh, he was very adverse. He was so hostile, yet he was a Jew. He was against us in the flag case and against us in the license tax case. Murray says, I read some of his opinions, and it was amazing that he, coming from a prosecuted minority, a Jewish minority, that he was so tough on the witnesses. Covington says, oh boy, you said it. He was really vicious too. He tried to justify himself, but he was a hypocrite really. And my feelings about that matter is that he is an enemy. Okay, that I understand. And he's not speaking of an enemy to Murray, but an enemy to the witnesses. Murray says, let me go back to the other point. In the Flaxwood case, the first one, we got an adverse opinion in 1940. And on Flag Day in 1943, it was reversed. Covington said, and the reason, and that's why the other person added the part about Flag Day. Okay, Covington didn't do that. The reader or the person who was transcribing this added the Flag Day because they put two and two together. But Covington didn't say what was said up first. Covington says, and the reason it was reversed because I brought an injunction case in the United States District Court for the District of West Virginia to sustain the enforcement of the state flag salute regulation that required compulsory saluting of the flag by children in the schools. I challenged that as unconstitutional, and that gave me the opportunity to force the court to take a position on deciding the matter again. I brought an injunction suit against the enforcement of the regulation, and it gave me the right to impanel what they called a three-judge statutory court. Pay attention to what he did, ladies and gentlemen. He brought an injunction suit, a suit for injunction against the statute, okay? And when he brought that statute, he said that the statute was unconstitutional, which forced the district court to convene a three-judge or a tribunal, a three-judge statutory court. That gave us automatically the right to appeal directly to the Supreme Court of the United States, not to the Circuit Court of Appeals. This was a calculation on his part. It is a tactic, and it says they didn't do certiorari, they did an appeal to the Supreme Court. This was a tactic on his part, and I'm thinking it's brilliant, honestly, because I've been trying to figure out how to do that, and he just told us. So like I said, we got a lot to talk about in the future. And that's the reason why I'm doing this. I'm trying to point out that there are some tactics that this individual used that were 100% on the money. That's why he was so successful. Let's continue. Well, it's a highly technical thing. Yeah, it is a highly technical thing. But it gave us a speedy and quick decision, and we needed a speedy and quick decision. Ladies and gentlemen, I haven't read this, but he talked about it was highly technical. And that's exactly what I was saying, that it was ingenious on his part, because that's all he did was use the technicality. When we were arguing in that case in the district court, Judge John J. Parker, who was from North Carolina, was presiding on the court. Then the Attorney General for West Virginia got up and said, well, it's not necessary for me to argue this case, because the Supreme Court of the United States has already decided this case for the Jehovah's Witnesses. As a consequence, Judge Parker said, Mr. Attorney General, if you're relying on the Gobitis case, you'd better argue this case. He said it wasn't necessary for him to argue. So Judge Parker said, you better argue this case. He was flabbergasted, and the Attorney General was taken off his feet, and he didn't know what to figure. Ladies and gentlemen, the Gobitis case, Jehovah's Witnesses lost that case originally. But there was another case that came behind that case that was one that Covington was fighting. The judge was trying to let the Attorney General know this case is being reheard by the Supreme Court, and they are leaning in the opposite direction because they're hearing the next case. And if they weren't going to lean in the opposite direction, they would have said the case couldn't come before us because we already decided. That was the point. That the judge was trying to let the Attorney General know, you need to come up with a better argument. You need to argue this case. Brother Murray says, but I thought once the Supreme Court decided on something that it was a final decision. This is where all you guys need to pay attention. This is the part that people need to pay attention to. Got to go back up one. The Supreme Court can always reverse themselves and reopen the thing. And that was the very thing that I had in mind when I filed that case to challenge that and to get them to reopen it. And the only way I could do it quickly was to get a 3-judge court. And then bingo, I got the case challenged, I could shoot right to the Supreme Court of the United States and bypass the intermediary appellate court. And that way we have them on the run. Told you it was a tactic, and I see what he was doing, and I am very impressed with that. Because now some of you are going to be getting some ideas. Like I said, I wish people would take the time to listen, because this video right here, this is not one of those, you can get out of jail free by doing this. Oh, you can pay all your bills by doing this. Oh, you can get your TVA account done by doing this. Oh, you can get your Social Security monies by doing this. Oh, you can become rich beyond your dreams. Just subscribe. This ain't one of those videos, people. This is me. This is not a video about Jehovah's Witnesses. This is a video about an attorney, Hayden Covington. This is this man after he had won before the Supreme Court 37 cases, having been before the Supreme Court 44 times. This is him giving you his legal expertise. A law professor? Most certainly. Let's go ahead and see what happens next. Says, that's interesting. Did somebody have some indication that the Supreme Court would be willing to hear it again? Or did you just think that? Covington says, I didn't have any inside information on that because we never get any commitment out of the court. I knew that when Roy Gamble, who was one of Jehovah's Witnesses, that's them adding that, who was painting the picture of Judge Murphy in Lansing, Michigan, as an artist there. It says he painted a picture and hung it in the Capitol there in Lansing. Said Judge Murphy made a statement to Roy Gamble, who complained about the adversity there that the Jehovah's Witnesses had been put in. Frank Murphy said to him, I know that. Someday we're going to do something about that. Okay, Judge Murphy said that. Remember, Murphy was the Supreme Court Justice. Anyway, Murray says, now let's see. I want to ask you something about the sedition laws because some of my friends had been involved in those sedition laws, particularly that one down in Mississippi. Oh, Mississippi, M-I-S-S-I, crooked letter, I-S-S-I, P-P, wee, I don't even care. Anyway, that Mississippi case we took up to the Supreme Court of the United States along with the second flag case, West Virginia Board of Education against Barnett. That's the case right there, I believe, that took care of the, give me the name. Where you at? Where's the name? Oh, Gobitis. That's the name I was looking for. That's the case that reversed the Gobitis decision. I took it on appeal to Mississippi case sedition based on the refusal explaining the reason for our refusal to salute the flag was in literature, and that had been distributed, and that was what the brothers were doing. putting literature out explaining why Jehovah's Witnesses do not salute the flag, and they were accused then of violating sedition conspiracy laws of Mississippi on that account. That was the case that we brought along with the rehearing of the flag case in the West Virginia case. Covington says they all devoted. That word I'm not used to. But anyway, in the court at the same time, and only Jehovah can do that. In other words, I believe he's saying they all ended up in the court at the same time. And that's how he got victory after victory after victory at one time. So many cases coming before the Supreme Court, they literally got tired. The papers, said Murray, said that they were filed, the paper said that there was a field day for Jehovah's Witnesses. Covington says that was what Judge Wyatt said, or Waite, however you want to say Wyatt. Yeah, I can handle Wyatt. Don't email me, text me saying, no, the name of the pronunciation is Wyatt. Okay, shut up. That it was a field day for Jehovah's Witnesses when they handed down those decisions on Flag Day in 1943. Look, the Supreme Court handed down a decision saying that Jehovah's Witnesses did not have to salute the flag, and neither did any of you, on Flag Day. You think that was a coincidence? Let's continue. Judge Wyatt wrote in an article entitled "The Constitutional Debt of the American People to the Jehovah's Witnesses," a long article in the Minnesota Law Review that covered about 40 pages. He makes a detailed account of the decisions that were handed down on that day that included Jones against Opelika being reversed, the Mississippi case being handed down and reversed at the Supreme Court of Mississippi. Yes, see, it was a field day for us. It turned the tide. Then the publicity turned the other way. The newspaper had been very adverse against Jehovah's Witnesses all over the country, and then when it gave them a licking, why, they went soft. Interesting. Let's continue, shall we? Murray says, it was like Jehovah got swallowed up. Jehovah, it's supposed to be Jehovah God swallowed up the flood of adversity coming from Revelation, the 12th chapter, verse, I believe it is 15 through 17. Okay, but anyway, those people, it's getting late, but there's a couple of more cases that come to mind. There's the one that involves me. You never knew the one that involved me, the draft case. Covington says, I was very much involved in draft cases because I had met with all of the military authorities in Washington when they were considering the cases of whether Jehovah's Witnesses would be allowed exemption from the draft under the law as ministers of religion, and whether they were entitled to the benefits of conscientious objector status. Jehovah's Witnesses around the world usually apply for conscientious objector status. It isn't that they won't do work in the military. What they will do is they will do work, civilian work, but they will not do any work dealing with the taking of arms and the harming of their brothers, no matter what land, no matter whose enemy they are. They had a big room full of guys. They administered the draft, and among the group was General Lewis Hershey. Oh, look at that, Mr. Hershey. I guess he's full of chocolate. Anyway, now you get the opinion from reading that he was more or less in favor of allowing conscientious objectors. Covington says he was in favor of giving us a good even break. He was really an honorable man, a man of integrity. I liked him very much. He died about 3 years ago in Indiana, in the country. He was an expert on the draft, the best in the world on conscription. That's why Roosevelt put him in charge of the draft administration registration. Anyway, he was a corny type of a man, but very brilliant, sharp and quick. He defended myself very well before Congress, and he was honorable and fair in his dealings with Jehovah's Witnesses. He agreed on certain of our demands, and I said, well, I guess we'll have to fight over the rest. Sister Murray says, well, I guess they got real emotional and patriotic. Covington says, oh, yes, but they were cold-blooded too, those army men. To them, that's just like cutting meat, They were as cold as cucumbers. Murray says, yes, to them, men was just pieces of material. And that's basically, you're just a number because there's too many of them to care about. Sorry, the military has too many men to actually care about every single one of them individually. How many of our brothers finally wound up in prison during the war? Covington says there are about 2,500 of them who went to jail during the war, but we kept an awful lot of them out. We had a tremendous number of cases that were taken up and appealed under the draft law, and there was a big day that we had in turning the tide in the Supreme Court in the draft cases that were about 3 or 4 of them that were all set together, and I argued them again because he was handling so many cases for Jehovah's Witnesses. This is where he's getting the victories from. I remember that. That was in the early 50s, wasn't it? And I'm going to stop here. Although I want to go past it, I'm going to stop here. The rest of you guys can go and read it yourself. Many of you have already stopped the video and gone and read it yourself, but you won't be able to pick up on the finer things. Anyway, Covington says, we lost the file book case. That was the first draft case, and they ruled against us on the grounds that we had not exhausted our remedies by taking an appeal. An appeal was taken inside the draft law. They held that we were supposed to have taken a second physical examination, and that was not necessary because the first physical examination was enough to settle the guy's eligibility physically for the draft. They took the position that it was necessary for him to go back and take a second one. I argued that it was unnecessary, unreasonable, and arbitrary, and conspicuous, or capricious. My sister's middle name is Caprice. Anyway, capricious, in order to get the benefit of law. Frankfurter, the judge who is now dead, and he is dead, was dead against us, and he was a lot, and so was a large number of the other judges. But in the end, we won those draft cases on the second go-round. That's right, he kept going back in. We established the right to be heard on our defense as ministers. At first, they held that we did not even have the right to make a defense, and then because of this business of not having taken a second physical, which I said in my argument to the court was not necessary because his acceptability had been predetermined by the first physical, Brother Murray says, so that's the one that was established when I came along in 1957. By that time, I wasn't pioneering yet, but I just told them that I was one of Jehovah's Witnesses, and they automatically gave me a conscientious objection. That did not happen in 1968. That problem still persisted. People were still drafted. People were still made to go to war. Covington says, we had a lot of difficulties in establishing that, but in the end, we prevailed. Jehovah gave us the victory in those cases. Not all of us got a deferment without difficulty, but in the end, we finally won in the draft cases. We got the decision from the Supreme Court of the right to make a defense in the case of the Lewis Dabney Smith case, who is now a circuit overseer down in this area. William F. Estef, the other one, was from Pittsburgh. Look at that. This man remembers all of these names, and Smith was from the South. Smith had an interesting case because his old man caused him to be kidnapped. His old man got the cops to kidnap him from home and took him down forcibly to the induction station. Oh God, they're inducing him? The old man knew that his son wasn't going to show up, so they forcibly took him down there. Lewis was there, and then I had to sue to get him out of the army. We went around and around in his case, and we also went around and around in the others. That was a big battle in that draft thing. We gave them a receipt For every blow, they were getting ready to indict me. You see? Yeah, they were really getting ready to indict him. Ladies and gentlemen, I'm going to stop reading right now. It's not that much further, but I just wanted you guys to, those of you who do law, who understand law, to understand the reason why I speak of this Mr. and why I can't think of his name, his first name, because I don't speak of Mr. Covington that much, but Hayden, okay? Attorney Hayden C. Covington, okay? Winning that many cases before the Supreme Court, and his strategy with bringing a case before the district court, an injunction case, where the district court had no other choice but to hear it on its merits and on the argument and on the case law presented. Ladies and gentlemen, I'm writing a document for somebody. I'm going to put you guys on hold while I get the document. 1 second, okay? Just want to show you something on the document, and so it'll be 1 second. I'm just starting this appeal brief, but the premise in this appeal brief is 1, introducing the facts to the case. Pay attention to this. Every matter brought before the court must be supported by evidence, i.e., witness testimony. That evidence must be reliable and directly associated with the subject matter. The use of case law is the court's and its officers' way of using witness testimony to support their claims. This fundamental principle comes from Scripture. The Supreme Court of the United States recognizes the use of Scripture. That's what I'm putting next, okay? That's what led me to Covington. And all I'm going to do is list those cases with Covington. You got it? Because he used Scripture in every single one of those cases, ladies and gentlemen. And if they were inadmissible, inapplicable, the Supreme Court would have said so, and they never did. Okay. In this continuum, examines the language of words, phrases, and provisions, as well as amendments, i.e., historical developments of the statute in which the provision at issue is found. The courts also took at the relationship of the statute with other related statutes and other provisions of the same act in which the provision is found, as part of the determination of whether a plain meaning can be ascertained. Arizona, California, Connecticut, Utah, Washington, and Wisconsin. These are the courts that have decided this. This approach used both intrinsic and limited extrinsic aids in the plain meaning analysis. What do they mean by plain meaning? I'll tell you in a second. The courts use the typical intrinsic aids, such as internal structure of the text, the context of the statute, the statutory scheme, the historical development of the language of the statute or provisions, the dictionaries, and the legislative draft manuals. Ladies and gentlemen, let's make sure we have something here. Let's make sure that we explain something here. Sorry, my phone is ringing. I have to take this. 1 sec. Sorry, ladies and gentlemen, had to take that call. Getting back to this. The reason for this whole motion and everything is the courts have been they've been playing games. The person I was just talking to, he's the attorney out of Texas who has been communicating with me about a couple of things, and he's actually has had some success in certain areas. In those areas, ladies and gentlemen, I'm going to be doing a video with him, and we're going to be sharing the information with you guys freely, giving you guys the template and everything, and putting his information up so you guys can bug him to death. He's an attorney, so he's going to love you. But other than that, well, he's not going to tolerate too much. And he charges, okay? So sorry, he charges. He ain't like me, okay? He charges. Getting back to this, ladies and gentlemen, this document right here, let me see if I can explain it to you so that you'll get it, because most people won't get it. Most people won't understand it. The first thing I did is I put this. Matthews 18:16 says, "But if he does not listen, take along with you 1 or 2 more, so that by the testimony," literally mouth, of 2 or 3 witnesses, every matter may be established, or everything said might stand. See references Deuteronomy 19:15, 2 Corinthians 13:1, and 1 Timothy 5:19. Legal definition of evidence is a matter of fact that a party in a lawsuit offers to prove or disprove the issues in a case. A system of rules or standards that are used to determine what facts may be admitted, to what extent a judge or a jury may consider those facts as proof of a particular issue in a lawsuit. Until 1975, the law and evidence was largely, we're going to get rid of that, a creature of common law. I was going to leave it because it said common law, but we don't need that. Okay? Now, do you understand why I'm using that information right there? Well, the reason why I'm using it is because we're going to use evidence. We're going to use court case as evidence. We're going to use scripture as evidence. And we're going to beg the court to try to see a way to stop it. Oh, okay, that's what that is. That right there. Okay, that was the problem. And we do that, and then we do that. Get rid of that blue line. And then we're going to do that, and then that. And that'll take care of that. Okay? So, oh, we got this blue line right here. Too much. Okay. Now, I'm not going to leave me alone with the blue lines already. Uh-oh. Get back. Automatic correction. It hadn't done that before. Now, all right. So that's just a little bit of an update to those of you. You don't have to be a rocket scientist to put together a motion. You just have to only state the facts, people. The court cannot consider conjecture. It cannot consider your opinion. It can only consider the facts. And most of you guys don't put the facts in your document, which is why they get dismissed. So just use facts. Well, what are the facts? Who, what, where, when, how, why? Okay? That's it. But you don't have to explain all the details. Just say, the defendant, blah, 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 did, in fact, blah, 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 on this date, blah, blah, blah. Just the facts. And then you go to the next fact, the next fact, the next fact, the next fact. You do the who's, then you do the what they did, and then you do when. Just look at another motion by an attorney. You see they're doing the who, what, when, where, how, and why. That's how they do, people. You know? You feel me? Gotta go. Take care of yourselves, ladies and gentlemen. Goodbye.